Historically, we always used to think that basically where a couple were divorcing, there would always be, to some extent, a conflict there because they didn't share the same collective interest. And that placed me as a lawyer in an impossible position because I couldn't act in both of their best interests. Experience has, however, taught us that this is something of a straitjacketed view. And that isn't always the case. In fact, quite often, particularly in those amicable and straightforward cases, there is no conflict at all, really. Yes, there may be the odd minor disagreement about matters, but that doesn't, in and of itself, create a conflict. And actually, what you do have is the overarching interest of both those parties, which is to deal with matters swiftly and amicably, and with the minimum of cost as possible. And a single lawyer can, in certain circumstances, facilitate that. Indeed, in the past, I have sensed frustration from clients when they come to me in a sort of scenario which you paint. And it seems to me clear that I could sort it out for them, but the feeling was that we weren't permitted to do that under our own sort of regulations and so forth. And then you get a client looking at you somewhat quizzically, actually, on occasion, thinking, well, I don't really see why my other half needs to incur additional legal expense, maybe even prolonging the issues, prolonging the case as well. And I'm sort of in agreement with them that was the view. However, now the views have changed, and I operate under the resolution together model with some colleagues within the Birketts family department as a whole, and we are now able to act in certain circumstances for both parties, as you know, for instance, where amicable, straightforward, etc., to assist them with resolving their case. You still go through the same process. That's disclosure, advice, leading hopefully to settlement, and then once a settlement's been agreed, then you sort of draft this into a binding consent order, which is lodged at court and sealed by a judge, and then the divorce is at an end thereafter. The benefits of it are obvious. The cost is much less because it's one lawyer as opposed to two. I think from a time perspective, it can be much swifter to resolve because you're not having to go between two lawyers. You're not getting things lost in translation. That's client to lawyer, lawyer to other lawyer, lawyer to the other client. So you're cutting out the middleman to some extent, which I think is a really good thing. I do want to stress that we will still operate in the same way. We'll still be advising both parties. And I think that's important. Another important final point to bear in mind is that it's not going to fit for all cases. Where the case is complex, where there is a power imbalance between the parties, the usual way of that rearing its head is where there's a financial information advantage from one party to the other, where there's concerns about domestic abuse, where there's a lack of trust, those sorts of cases. And now we often see those. It's often why they're going for a separation or divorce in the first instance. But in those situations, it's probably not going to be ideal. And that's just the way it is. It places us in an impossible position, basically. Yeah.